Morning, everyone. I'd like to welcome everyone to our Hamilton County Board of Election meeting. Today is July the 9th, 2024, and we're calling the meeting to order at approximately 8:35. And we must begin our meeting first with the Pledge of Allegiance. And I would like anyone who has served our country or is serving our country to please lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And I want to thank those who have served our country and or are serving our country. Thank you much. We're going to follow the agenda this morning as we normally do. First, we're going to approve the board meeting minutes from June the 11th, 2024.
I know those were circulated. I'll move approval of the June 11th, 2024 Board of Election meeting minutes.
Second.
Any more discussion? All those in favor?
Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Next on the agenda is a registered voter challenged hearing. And I'm just going to take a moment and explain the process. Thank you very much. I'm going to recognize first our administrator, Kurt Eckert, to introduce the matter before the board. So this is an administrative hearing under which the board is operating in a quasi-judicial capacity. The formal rules of evidence do not apply. The board requests that council cooperate regarding the admissibility of evidence. If there is a disagreement between the council as to the admissibility of any exhibit, the exhibit will be admitted. And council can make arguments before the board regarding the weight of the evidence, which the board will take under consideration. Both parties may call witnesses who will be sworn in by the court reporter, and that's our court reporter right there. The challenger, there will be an opportunity for the challenger's counsel to offer rebuttal and for the challenged voter's counsel to respond to the rebuttal. So I'm going to recognize the challenger's case and recognize Attorney Kurt Hartman to present the challenger's case. Mr. Hartman.
Thank you, Madam Chairman.
And there's no need to swear in Mr. Hartman. He is an attorney, a presenting attorney for the challenger. Any witness he calls could be sworn in by the court reporter. Thank you. And after the evidence, the board members will have the opportunity to ask any questions of the challenger's counsel. Mr. Hartman.
No problem. If you'd like, Madam Chair, I can do a brief opening and then call Ms. Bailey to testify, is what my intent would be.
That's what our intent is as well.
Very good. This simple challenge, we have here a voter who is still currently registered to vote, what I believe is her mother's residence in Anderson Township. The evidence clearly establishes a permanency of residency in Jefferson County, Kentucky, that is Louisville. Ms. Cawtha, I think the evidence will come out through her testimony, is a licensed doctor practicing in Louisville, has been there since 2016, and essentially has purchased a condo and lives out of that condo in Jefferson County. There is no Ohio medical license, so practicing medicine is not occurring by her in the state of Ohio. And this is a simple case where this isn't like a college student who has, gone away temporarily for college. This is a person who has established permanency in the Commonwealth of Kentucky. So with that, I would ask to call Jessica Cawtha as a witness.
Thank you. Ms. Cawtha, can you step forward, please?
No problem. For the record,
If I may, Madam Chair, I'd just like to be recognized as the doctor's attorney, and I will be here.
Recognize Mr. Tim Burke, please. Thank you.
for the record, would you please state your name?
Jessica Cote.
Cote, and I. Oops.
You can project, can't you? You can
I
project.
would just like to say, share the microphone in peace and harmony, please. That's okay. She's okay. She's a strong woman. I feel that she's not intimidated by a microphone.
No problem. Very good.
Proceed.
Very good. Again, for the record, would you state your name?
Jessica Cota.
Okay, Ms. Cota, where do you currently reside?
I split my time between here in Cincinnati and Louisville, Kentucky.
Okay. Where are you employed?
In Louisville, Kentucky.
For whom?
Norton Healthcare
And how long have you been employed by Norton Healthcare in Louisville, Kentucky?
since last September.
Okay. Have you been practicing medicine in, strike that, for how, are you a doctor, a medical doctor?
Yes.
By which state or states are you licensed as a medical doctor?
Currently only in Kentucky.
When did you obtain your medical license in Kentucky?
Well, I first obtained a provisional license while practicing medicine in the context of residency, I believe, in 2017.
Okay. You graduated from the Ohio State University College of Medicine in 2016, correct?
That is correct.
And then you proceeded to move to Louisville, Kentucky, correct?
I matched to the emergency medicine program at the University of Louisville.
Correct. And also in 2016, you purchased a residence in Jefferson County, Kentucky, correct?
Both my mother and I purchased that condo, yes.
What is that address?
1409 Mockingbird Terrace Drive, Unit 305 in Louisville, Kentucky, 40207.
You executed a mortgage with respect to that residence, correct, in 2016?
Yes,
And within that mortgage, you represented and certified that that would be your primary or principal residence as part of the condition of that mortgage, correct?
I don't recall.
Because I do think it is relevant, could you please give me your date of birth, please?
July 8th, 1990.
Have you applied for an Ohio medical license? It's going to go to whether any intention to come back to the state of Ohio. Or if she's only licensed in Kentucky, it clearly demonstrates an intent of established permanency in Kentucky. She's licensed in Kentucky. She's already acknowledged that. She owns a condo in Kentucky.
Mr. Stevenson puts us all in an awkward spot here, certainly having ruled on lots of these in my lifetime, but how should the court deal with an objection? I mean, it's already been stated by our chair that the rules of evidence don't apply. Not sure if Mr. Burke should just note that for the record and we move on, but I looked at counsel rather than supplanting my judgment for yours. I would ask you as to how our board chair ought to handle an objection.
That's what I thought, null and void, and I'm not an attorney.
So
I think she
she
needs
can
to
answer
answer.
the question then. Have you ever applied for a medical license in the state of Ohio?
Not yet. I intend to return and at that time would apply for a medical license.
So the answer is no, you have never applied for a medical license in the state of Ohio, correct?
I have not.
With respect to the address in Anderson Township at 1106 White Pine Court, do you own that property?
It's my family's home. I do not own it.
So the answer is no, you do not own that property,
I do
correct?
not own the property.
But you do
My
own the
mother.
but you do own in fee simple the property in Jefferson County, Kentucky, correct?
My mother and I do, yes.
Did your mother co-sign on the loan for the property in Kentucky?
Yes.
And that is why she is also listed on the title and on the mortgage, correct?
Yes.
From Monday through Friday, generally speaking, on any normal week, Monday through Friday, Where do you spend the evenings?
My schedule is not as defined as Monday through Friday. I'm an emergency medicine physician, so I do shift-based work. I have a contractual obligation to 10-hour shifts a month, so there's no defined period of when I might spend my time Monday through Friday.
Or the predominance of your time you spend in your, is it a condo in Kentucky?
It's a condo.
So the majority of your time, though, on any week, any month, you spend the evenings at your condo in Kentucky, correct?
If we're going to say more than 50%, most likely,
That's what a majority means, correct?
then I would probably spend a majority of my time in Kentucky.
Do you pay Ohio State income tax?
I do not hold a job in Ohio, so no, I do not pay Ohio State income tax.
But you claim to be a resident of the state of Ohio, correct?
I do consider this my permanent home, yes.
Do you realize that if you are a resident of the state of Ohio, you are legally obligated to pay Ohio State income tax?
I do not know the legalities of it.
I have no further questions, Madam Chair.
Thank you very much. Mr. Burke?
Doctor, where did you first register to vote?
Here in Cincinnati,
And when was that?
when I turned 18,
And have you continually maintained your voter registration here in Ohio?
yes,
Have you ever been registered in any other state?
no,
Where did you attend undergraduate school?
Tulane University,
And while you were in Tulane, did you ever register in Louisville? I'm sorry, in Louisiana.
no,
And when you attended Tulane, where did you intend to return upon graduation?
Cincinnati.
I think we've already established.
Continue.
But I need to make sure I preserve any error.
Mr. Hartman, please, you, right, at this,
to put on the record the basis for my objection.
but we must allow him, as we allowed you, to continue to ask the questions.
And you allowed him to object as well.
Mr. Burke, continue.
And when you completed your medical degree at Ohio State, to where did you intend to return as your permanent residence?
Cincinnati.
And while you were attending Ohio State, did you register to vote in Franklin County?
No.
And can you explain to the board how the selection of your residency worked?
So when you are a final year medical student, you essentially create a list of programs that you would be interested in attending, and the programs also create a list of candidates they would like to have at their program, and a computer system, it's called the match, a computer system decides where each student will attend their residency.
So in your case, did you select Louisville to be the place where you would do your medical residency?
No.
And when you took your medical residency in Louisville, how long did that last?
3 years of emergency medicine residency, followed by 1 year fellowship in advanced emergency ultrasound.
So when did you complete your residency?
In total, completing residency and fellowship in the summer of 2020.
And when you completed your residency, where was it your intent to return?
As you can imagine, 2020 was a difficult year, especially in the medical field. I chose to stay in Louisville because I did not have a job offer here in Cincinnati.
But ultimately, to where did you intend to return?
Here in Cincinnati.
And when you ultimately took, and by the way, you indicated that 2020 was a difficult year in medicine. Why was that?
The COVID-19 pandemic.
And when you took your job in Louisville, having completed your medical residency, did you intend to make Kentucky your permanent residence?
I've always considered Kentucky to be a transient stop on my journey.
Have you continuously resided in Kentucky for more than 4 years?
I am frequently here in Cincinnati, so I've not continuously been in Kentucky for 4 years.
How often do you return to Ohio?
Typically monthly.
And when you return to Ohio, to where do you return?
1106 White Pine Court, my mother's home.
And when you return roughly once a month, how long is your stay here in Ohio typically?
Anywhere from 3 days to 6 weeks, I would say on average about a week.
And do you maintain a bedroom at 1106 White Pine?
Yes.
And do you keep personal property at 1106 White Pine?
Yes.
Do you receive mail at 1106 White Pine?
Yes.
Where is your car registered?
At that address.
What license plate do you have on your car?
An Ohio license plate.
What address is on your driver's license?
The 1106 White Pine Court.
What's your phone number?
513-236-7227.
Is your current job in Kentucky intended to be permanent?
No.
What ability do you have to change that?
Hopefully on obtaining a job offer here in Cincinnati.
And are you making efforts to obtain a job offer here in Ohio?
Yes.
I have no other questions at this time.
Thank you.
Just a few follow-ups. You indicated in 2020 you stayed in Kentucky, correct?
Yes.
You stayed at your condo in Kentucky in 2020, located in Jefferson County, Kentucky, correct?
Yes.
That's because you owned that property, correct?
I do.
And you said your vehicle is registered in the state of Ohio.
Yes.
Do you realize that if you had registered your vehicle in the Commonwealth of Kentucky, you would have to pay significantly more fees because they impose an ad valorem tax on vehicle registrations?
No, I don't have any knowledge on vehicle registration.
But do you
in
realize that by
Kentucky.
registering in Ohio and not Kentucky, you're paying a lot less fees to the government to register your vehicle?
I don't have any knowledge of that.
You said you are currently trying to get employment in Cincinnati?
Yes.
With whom?
So I've interviewed with a few local groups.
Such as?
So I have turned down some offers from qualified emergency specialists and U.S. Acute Care Solutions.
Say again? Who was, I didn't hear the last part.
U.S. Acute Care Solutions.
Okay. You got a job offer from them
Yes.
and you turned it down.
Correct.
Anybody else that you've received a job offer from in Cincinnati?
Not in Cincinnati.
Who else have you applied for jobs in Cincinnati?
Compass Emergency Physicians.
Do they require that you have a medical license from the state of Ohio to practice for them?
Typically, one would accept an offer and then apply for the medical license.
So you have not applied for a medical license in the state of Ohio yet?
Correct.
How long is the process to obtain a medical license once you apply?
A few months, probably. As is credentialing for a hospital.
So you would have to apply for a job in Ohio, get the job offer, accept the job offer, then apply for the license. What happens during those 3-4 months interim while you've accepted a job but you can't work for them as a medical doctor?
So it takes several months to be credentialed by a hospital to be able to work. So it's roughly the same timeline.
What's going on during those 3-4 months, several months? Are you still working, would you still be working in Kentucky even though you're leaving that, your employer, North Care Healthcare?
Either that or maybe a vacation.
What affirmative steps have you taken to obtain a medical license in the state of Ohio, if any?
I have not applied for a medical license in Ohio.
You have not taken any affirmative steps to obtain a medical license in the state of Ohio, correct?
I have not applied for a medical license.
Have you
in Ohio.
taken any affirmative steps?
I'm not sure to what you're referring.
Have you done any proactive thing to obtain a license in Ohio? I know you haven't applied, we all know that, and we know you're not licensed in the state of Ohio. But have you taken any affirmative acts towards that end?
So the act would be applying.
Okay. Nothing further. Thank you.
Thank you. Madam Chair, I just have a couple questions of clarification, and maybe this was
Thank
covered,
you.
and I was taking notes pretty feverishly, so I apologize, Doctor. So your current status in Kentucky on the employment side is not as a resident, but as a full-time employee, just to be clear?
Yes.
Okay. And your residency, you said, ended in 2017?
2020.
2020, I'm sorry. Yep. Nothing else from me. Thank you.
And I have just a question. Based on your response to the other additional job opportunities, just help me, I think I understand this. You don't have to take or accept any job that's offered to you. You would, from my perspective, if you are a qualified physician, you're going to, and you are, that you'll want to take the job that best fits your qualifications and one that you choose.
That's correct.
Not just a random job just to be a job. Am I correct?
Yes.
Thank you. Any other? So now I'm going to advise the board that we have a couple of actions. You may have a
Thank
seat.
you.
Question.
No, do you? Yes.
So once you graduated and you started attending, you moved to Louisville for the job, did you always have the intent to return here to Cincinnati?
Yes.
Okay. And you voted every election since you were a registered voter?
Can I say I voted every election? No, but majority.
But you've never tried to register in Kentucky?
I've never registered elsewhere.
Okay. You've never voted outside of Ohio?
Never voted elsewhere.
Okay, thank you.
Any other questions?
I have one more question. This is something I was thinking about. So the voter challenge was brought by someone by the name of Rebecca Bailey, is that correct? Mr. Hartman?
Correct.
Okay, is Miss Bailey here? Okay. Can I ask her a question?
Mr. Burke, I mean, I think if we,
Well, I wanted to know, did she have any personal knowledge, since you're her mouthpiece, did she have any personal knowledge?
Now, I'm going to object to that comment of mouthpiece. It's unprofessional, and it shows bias on your part.
I don't think so.
You can recuse yourself from this hearing.
You're her attorney, you're representing her, you're speaking on her behalf. I'm asking you,
Attorney, and I've asked for the respect that I have, that any attorney would expect from any judge or trier of fact.
point well taken.
By your terminology and condescension of using the term mouthpiece, it's unprofessional.
Point well taken.
And it shows bias.
No.
I ask for your recusal.
at this point, I'm not going to accept a recusal. I think there were some comments that's been made earlier that I feel should have been addressed and has not been addressed, so we will continue with the procedure. But I just was wondering, since you are the attorney for the woman who filed the charge, does the individual that filed the charges, do they live in Hamilton County?
No, they do not. She lives in Warren County.
So she lives in Warren County, so she votes in Warren County,
That is correct.
but she does not live in Hamilton County, correct?
That is correct.
Thank you. That's all I had to say.
Because the statute no longer requires one to be a resident of the county, but to be a resident of the state of Ohio.
Thank you. Mr. Burke, do you have any other questions?
At this point, I do not. I don't know whether or not Kurt intends to call any other witnesses at this point.
On Kurt's case, so it's still his.
I do not.
Okay. Any other questions, Mr. Burke?
Not given what the record is at this point, I'm prepared to make argument whether that is
So,
appropriate.
Mr. Burke, you're not calling any witnesses, just to be clear? You,
Well, because I had the opportunity
Yeah.
to question my client, I don't think I need to call any other witnesses.
fair enough. Yep, I just, in our little procedure here that the chair laid out,
I appreciate that.
Yeah, I just wanted to be sure you didn't have anyone, and then, since he doesn't have a case, there's no rebuttal, and then we just move right to it, yeah.
So now the board has three options. The board can deliberate and offer, I'm sorry. Oh, okay. Okay. Kurt, would you go first? Make your argument, please?
No, no problem. In terms of determining voter registration, the board should get due deference to one's self-serving declarations of intent. The board actually needs to look at the entire evidence as well. As I indicated in the opening, this isn't a college student who is transient, goes off to college. In those circumstances, oftentimes, because the college is truly a transient situation, students regularly maintain their residence where they initially registered when they turned 18. And as Ms. Kotha indicated, she registered to vote at this address on White Pine Court when she turned 18. That's logical. She goes off to college, goes off to medical schools, maintains that residency. That's fine, and that's normal. But here we're not talking about an 18, 19, 20-year-old person. If my math is correct, about 34 years old, 35, who has got a full-time job in another state, who the only real property she owns is in another state, who, despite claiming to be an Ohio citizen, doesn't pay Ohio income tax. I mean, I look at myself. When I went off to school, when I served in the military, I maintained my Ohio residency. Even though I lived in the state of Florida, I was stationed in the state of Florida and could have declared residency and not paid income tax. I maintained my Ohio residency in Ohio and constantly paid Ohio income tax. That is, I think, is the strongest demonstration of maintaining the tie, because it's respecting the system. But on the one hand, to claim residency for voting in Ohio, and then avoiding your legal obligation to pay income tax if you're a resident, that shows a lack of credibility. That shows I no longer have an intent to be Ohio. I've gone to Kentucky. I've got a full-time job. I obtained my professional license from the Commonwealth of Kentucky. Has done nothing to get that same license in the state of Ohio. So as a 34, 35-year-old person, full-time employment, only residence owned is in Kentucky, there's clearly an indication that residency is Kentucky, not Ohio. You know, it's one thing to visit your parents. I visit my parents all the time. But I have my own separate residence that I own. That is the demonstration of intent to make another place your permanent abode. You know, and in 2020, during the COVID crisis, when everybody was locked away, where did she stay? By her own testimony, was Kentucky. Thank you.
Mr. Hartman, I have a question. I'm going to ask Mr. Burke the exact same question.
Okay.
You had to know this was coming, given our long history on this board. In 2015, the First Appellate District decided the case of Howardell versus this board,
Right,
and
I'm
you
familiar with
litigated
the
that
case.
case. That was a case of Randy Sims. By the way, I remember it was S-I-M-E-S, but he specifically pronounced it Sims, which is why I'm pronouncing it that way. Anyway, and in that case, candidly, I voted with your position at the time and your client's position.
Correct.
And the court, First District Court, told us we were both wrong. So I wasn't just playing on my phone. I was rereading the gist of that opinion, the State ex-rel Howardell versus Sims, where, again, the First District Court of Appeals presiding Judge Hildebrandt wrote an opinion on this topic, giving us guidance. It essentially, you know, it's, I think some of the fundamental language, and again, our obligation here is just to follow the law, but some of the language there made it clear that we're to give deference to a voter's intent. And it disagreed with my position at the time, which was the same as your client's position. I'm curious to know how you would tell us this is different than Sims. And again, our obligation here is to avoid litigation for the board. So how do we avoid that litigation?
I would also refresh your recollection that case actually did go to the Ohio Supreme Court, which would then have a superseding decision.
Sure.
So the First District decision itself may not be
Understood.
controlling
Yeah.
the precedential. And essentially what the Ohio Supreme Court said there is, you know, the court's review of this board's decision on a voter challenge is deferential, because this board is sitting as the trier of fact. And that's what I think the Ohio Supreme Court in the Howardell decision basically said, is we defer unless there was an abuse of discretion by this board in its determination.
But they never got to the question of an abuse of discretion, did they?
No, the Supreme Court did, I believe, in the case. And that was the basis for its analysis. But I think that the law is clear that if it was as simple as one person coming in saying, it is my intent to make that my permanent abode and to return sometime 20 years, 30 years, 40 years, 50 years down the road, then all other facts are irrelevant? No, all facts must be relevant and considered, and the court and the board should give, due weight to a person's declaration, but that's not the exclusive standard. It is a factual inquiry. It's a credibility determination. I would argue, I find it beyond credulity that a 34, 35-year-old professional doctor who obtains a medical license. I mean, it would be like me saying, yeah, I have my medical license in Ohio. My legal law license in Ohio, but I really intend to make Illinois my permanent abode if I grew up in Illinois. I got to do something to kind of show the definitive affirmativeness. If I'm my full-time job, professional license, no act to try to even get that license where I claim I want to go, I think it questions the credibility. And again, if somebody buys a house, and look at the mortgage, it's part of the record. I assume the complaint tendered under election falsification is part of the record. In that mortgage, you attest that this is going to be your permanent place, or primary, I think the language is primary residence in any mortgage, and it's in this mortgage. So I think, like I said, but back to your question more so, the Howardell decision, this board makes the determination. The courts will be deferential to that factual determination, but it's not a one-question inquiry and the end of the case. You got to look at all the facts. And again, this isn't a college student. This is a professional doctor, full-time employment, residency, not paying state income tax in Ohio. Thank you.
Thank you for that. Appreciate the explanation.
Thank you. Mr. Burke?
I'm going to refer to several, in addition to the Sims case, I think there are 6 copies there. First of all, let me point out that it's undisputed that Dr. Kotha returns on a regular and essentially a continuous basis to her longtime home and bedroom here in Hamilton County. She has property, her personal property there. She receives mail there. Yes.
Sorry, we are distributing all of these, and it's hard for me to pay attention to you both, but you give us 30 seconds.
Certainly.
Are there 4 exhibits, Mr. Berg?
Yes, sir.
Okay. Thank you.
Okay.
Thank you.
Thank you.
And those facts are very similar to critical facts that the Ohio Supreme Court has considered in other cases involving voter residency. And let me walk you through these 4 exhibits. First of all, Frank LaRosa's website contains a question, where is my residence for voting purposes? And as it's summarized, you lose your voting residence if you have moved to another state and vote in that state, or if you have moved in another state with the intent to make that state your permanent residence. She has not done that. And in fact, keep in mind that she ended up in Kentucky not by her choice to begin with. She ended up in Kentucky for her medical residency, which she was directed to as a part of how medical residencies are established. And the secretary points out that you move to another state and continuously reside in that state for a period of more than 4 years. Her residency has never been continuously in Kentucky because she returns to her permanent residence in Anderson Township on a regular and routine basis. For long weekends, and sometimes, as she testified without dispute, for longer periods of time than just long weekends, up to 6 weeks, in fact. And part of that is because of how her emergency medical profession works. It's not a 5-day-a-week, 8-hour-a-day job. It's 10-hour days in a month. That's nothing like what a 40-hour week would be. The Ohio Revised Code in section 3503.02 makes the same points, and that's Exhibit 2. The place shall be considered the residence of a person in which the person's habitation is fixed, and to which, whenever the person is absent, the person has the intent of returning. Now, Kurt wants to say he knows what the doctor's intent is. He doesn't know the doctor's intent. Only the doctor can tell you what her intent is. The statute goes on, a person shall not be considered to have lost the person's residence who leaves the person's home and goes to another county of this state, another state or county of this state, for temporary purposes with the intent of returning. The doctor has testified without dispute of her intent to return, and in fact, she does return on a regular basis to her home in Hamilton County. And look, it's not unusual for anyone to own more than one property or to have more than one residence. And the courts have said it's up to the voter to determine what that residence is. And I'll go to, while it's a relatively old case from 1952, it is another case out of Hamilton County, the Klink versus Irick case. And in that case, the voter whose registration was challenged actually had a family that lived in Franklin County while he maintained a residence here in Hamilton County. And the Supreme Court says it's arguable that there was substantial evidence tending to indicate the Cincinnati address which Mr. Shore, the questioned voter, gave as his voting residence in his declaration of candidacy. If that was then that place considered to be his residence. However, the evidence discloses that whenever Mr. Shore is away, and even when he is in Cincinnati, he has the intention of returning to his Franklin County house. In other words, any intention he may have to return to Cincinnati is remote, as distinguished from the immediate intention which he has of returning to Franklin County. But the court goes on. On the other hand, paragraph B of what was then section 4783-8531, General Code, represents a modification. Admittedly, Mr. Shore at one time fixed his habitation in Cincinnati. There is substantial evidence of Mr. Shore's intention to return from Franklin County to Cincinnati. Also, there is evidence that he has not gone to Franklin County for permanent purposes. It is the antithesis of permanent purposes is a temporary purpose, as the words in paragraph C of the statute tend to indicate. And the court goes on finally to say, both parties rely on paragraph J of the statute. What that paragraph means depends on the meaning of absence. Certainly there has never been a period of 3 years when Mr. Shore, or in the doctor's case 4 years, was not in Cincinnati. The doctor is here every month. So it may be argued that he has not been absent therefrom in excess of 3 years. The court says, in our case now, 4 years. And critically, I use this old case because the Ohio Supreme Court referred to this case as recently as 2009 in dealing with the Husted case, when the voter residency of the current lieutenant governor and prior Secretary of State was challenged. And the Supreme Court noted in the Husted case that Husted, while his family lived in Franklin County, he returned at least weekly to his home in Dayton, or just outside of Dayton. But the court goes on, the registration of a registered voter shall not be canceled except as provided in section 35, in chapter 3501.05. And we've gone through what the specific requirements are for establishing whether or not a voter has retained their residence. The critical language in the Husted case is this. Because of the sometimes conflicting nature of these sections, when multiple sections are applicable, as here, it is difficult to find by clear and convincing evidence that a person is not a resident of the county claimed. That is, the rules which the General Assembly specified were apparently intended to enable an individual in such a situation to select as his residence some place which fairly conforms with one or more of the several rules specified, even though it might not conform with some of the other rules so specified, or might not be his domicile. Consequently, when the applicability of multiple sections leads to conflicting results, it cannot be shown by the heightened standard of clear and convincing evidence that the person is not a resident of that county. And great weight, the critical language, great weight must be accorded to the person's claimed voting residence. And the court, in the end, cites to the Clink case, noting, for example, we held that a Board of Elections properly decided that a married person whose family lived in Franklin County was a qualified voter in Hamilton County because of substantial evidence that the person intended to eventually return to Cincinnati. The evidence from Dr. Kotha is absolutely undisputed of her long-time intent to return to Cincinnati. Evidence demonstrated by her continuing to come back and live in the bedroom that has been her bedroom for all her life. That's an intent to return here. That should answer this question, and any dispute of her voter residency should end as a result of that intention. Thank you. I'd be happy to answer any questions the board may have. Thank you.
Any board members have any questions? Can you, Mr. Hartman, just a moment. I was in the process of asking our board if they had any questions.
I apologize,
of Mr.
Madam Chair.
Burke. Mr. Burke, could you step to the podium again, please?
Yes, ma'am.
Okay, does the board have any questions of Mr. Burke?
I do not.
Thank you.
Thank you. Mr. Hartman?
I would note, I think Mr. Burke tried to provide a lot of evidence. She sleeps in her bedroom, that she always did. There was no evidence of that, and there's other examples that I heard during his closing argument. Yeah. And as I've indicated, I think to Mr. Triantafilou's question, I think the declaration is to be given substantial respect, but it is not exclusive, and the courts have never said it is exclusive. What we have here, which we don't have in the Husted case, which was a situation of a state legislator going temporarily to Franklin County for a part-time job as a legislator and coming back to his residence in Montgomery County. We don't have a part-time job here. We got a full-time job here. But what I think this board needs to be guided by is the mandate given to it by the General Assembly in 3503.02. It's interesting. I looked at the Klink case that Mr. Burke provided, and on the second page it highlights certain provisions of the old General Code of Section 4785-30, and he, like he does in his Exhibit 2, the current provision of that 3503.02, he likes to point at divisions A and B. Place shall be considered the residence of a person in which the habitation is fixed and to which, whenever the person is absent, has intent of returning. And then B says, a person shall not be considered to have lost the person's residence who leaves the person's homes and goes into another state or county of the state for temporary purposes only for temporary purposes, with the intention of returning. We don't have somebody going to Kentucky temporarily. But what he does in this Klink decision, he notes that Division F is no longer part of the law. And that's right, that provision is no longer part of the law. The General Assembly updated it, and if you look at the current provision of law, 3503.02F, it says, except as provided in Division G, which deals with a person in the military, which we do not have here. If a person removes from the state and continuously resides outside the state for a period of 4 years or more, which is what we have in this case, the person shall be considered to have lost the person's residence in this state. And here's the key thing. Notwithstanding the fact that the person may entertain an intention to return at some future period. Notwithstanding the fact that the person may entertain an intention to return at some future period, this General Assembly has dictated, that you go outside and reside for 4 years or more, you've lost your residency in this state. That is the provision that is at issue, that applies, that controls, that dictates the decision in this case. She bought the house in 2016. She did her residency during the COVID in 2020. She stayed in Louisville, and she has been there ever since, continuously. She's moved and continuously resided outside this state for a period of 4 years or more. By 3503.02F, she has, as a matter of law, determined to have lost her residency here. That is what controls, notwithstanding any declaration of intent. Thank you.
Mr. Harmon, do you have any, I know you covered the distinction that you see in the Klink case, but again, we run up against this idea, having been on the losing end of one of these already. The Bruner case is a Supreme Court case from 2009. I'm sorry, Husted v. Bruner,
Right.
State v. Bruner. Again, a unanimous opinion of the court that, again, found in favor of Mr. Husted, allowing him to stay in his current voting location, despite what was pretty significant evidence that he was spending a fair amount of time in Columbus. I remember that decision, had a chance to go back through it here. Can you distinguish that one from your client's perspective?
Yes, and in Husted, that was an intrastate issue. This is an interstate issue. Division F, which I believe dictates and controls the decision, makes no reference in terms of moving to a different county. That is clearly addresses only the situation that we have here that was not present in Husted. Continuously resides outside the state for a period of 4 years or more. Division F was not even applicable in the Husted case because the Husted case was intrastate. That division in this case deals with interstate moving and interstate living continuously for 4 more years. It's been almost 8 years now. And again, all the other facts, I think lack of paying taxes to the state of Ohio supplements that. But I think for the most part, that's not even relevant because of that division. And what is also not relevant pursuant to that division is her, whatever declaration of her intent, because the statute specifically says, notwithstanding that. So that exempts all of this other stuff that Mr. Burke wants to rely upon. Notwithstanding that, that statute dictates the decision as a matter of law.
Thank you.
Thank you.
Madam Chair.
Yes.
Mr. Hartman, sorry. Your reference to Section F, in my opinion, you rely heavily on the phrase continuously resides outside this state. We've had undisputed evidence that she comes and goes frequently and is here in Cincinnati and in Anderson Township on a regular basis. How do you distinguish between what is undisputed before us and, the definition, sort of just, I pulled it up, the definition of continuously is without interruption. And so, tell me how you square that.
I think, well, if you also consider the fact, like Mr. Burke argued, that yes, you can have more than one residence. The fact that you have more than one residence doesn't mean one is not. I mean, the word continuously resides. I mean, in a certain sense, if I fly through an airport, am I not in that state and no longer? I mean, do you almost have to live exclusively 24/7, 365 days a year? I don't think that's the law. That's an absurd interpretation in terms to say you have to be there 24/7, 365. And I think that's the premise of your question. If for 1 minute one is not continuously, i.e., without interruption in one state, that's not the intent of that statute.
Well, that's why I'm asking you the question.
That's what I said.
I mean, you relied on that phrase,
Right.
continuously resides.
And she has. I mean, the residence has continuously been in Jefferson County since 2016. Her testimony is that. She has continuously resided in Jefferson County, without interruption. She was there for her internship, bought the Brett condo in 2016, and has continuously, without interruption, been there. The fact that she may have not come to Ohio, may have gone, she goes to vacation, on a vacation for a week, is she still not residing in Kentucky? Or where, let's put it that way. Heaven help me if anybody goes on vacation, then they're no longer residing. No, that's not the intent. And I think to suggest otherwise, I think to suggest a 24/7, 365 criteria with no deviation from that, that's not the intent of the legislature, which ultimately is the law. So I think the evidence undisputably establishes, because she's the full-time employment, owns the property there, has been there since 2016. When COVID came in 2020, that's where she said she resided, clearly establishing that was a continual residency over that time. It wasn't like she moved to a different state for a month, a year, that she got a new apartment elsewhere, started employment elsewhere. She's always been there in Kentucky.
I was going to ask Mr. Burke that question, board member. So, Mr. Burke, could you step to the podium, please? Because for my clarification and my experience, having worked in the healthcare field almost all of my career, I know that when residents come into a program at the hospitals, they are not considered permanent. They come in, they go out. But I thought I heard the applicant state that she works 10-hour shifts and then maybe 2 or 3 or 4 per week, and then she goes home. And so, in my knowledge, when residents are pulling those long hours and maybe more, they're not normally, reasonably, they haven't really gotten that much sleep. So, but I wanted to make sure I heard that correctly, because my experience has been, if a resident has pulled that many 10-hour shifts in a week and has no place to sleep or stay comfortably, they would go home. Am I correct?
If I may, Madam Chair, let me make a distinction between the period of her residency and when she concluded that in 2020.
That's what I needed to know.
In the residency, she was clearly there, not at her choosing, but as assigned in the process of her medical education. Her current employment is, and residency may involve much longer hours than even what I'm about to say,
Yes.
but her current employment is 10-hour days, 10 times a month.
Okay.
That does create the situation that you've talked about. It also creates a situation where she is able to come back to Hamilton County on a very regular basis. And we're not talking about the vacation that Mr. Hartman wanted to use as explaining when something is not continuous. Her residency in Kentucky is clearly not continuous, given how continuously she returns to her mother's home and her bedroom here in Hamilton County. Thank you.
I have a question. It's a rare opportunity to get you on the legal hot seat.
I understand that, Mr. Chairman.
With all respect, I am curious, and I found your client's testimony credible that she intends to stay, okay, or intends to return eventually. So I'm not challenging that at all. But hypothetically, at some point, that runs out, doesn't it? I mean, in the sense that how long can she continue to say that? And then how does this board grapple with someone who just continually says, I don't know where Randy Sims is registered now, but I sure would like to know. Randy Sims, as you recall, I know you probably do, that was a case where he went to Korea.
Correct.
And I voted, again, with Mr. Hartman's position, it was a 3-1. The court found in favor at the time of Mr. Sims, allowing him to continue his residence here, even though he'd been in Chicago and then Korea. So again, I'm mindful of
I
that.
recall that. I was part of the winning side in
Yes,
that
yes,
one.
yes, indeed you were, and I disagreed with you as I did many times. But anyway, but just again, as this board grapples with this issue again, 9 years later, at what point does it run out? At what point do we look at somebody like Dr. Cota and say, your intention can be what you say it is. However, you've been so long in Kentucky, and that's the area of this that's a little unclear to me. So that's why, frankly, I asked about when her residency status ended, not because that was determinative of my position. I don't know what it is just yet, but I will tell you that to me there has to be some end to that. I'm curious to know your position.
I don't think there is a black and white line that establishes where that end is. And even the court's decisions, which you've looked at, and the experience which this board has had in dealing with voter residency issues, we all discovered in the process that how residency gets defined is not always clear. And that's why the court has continuously pointed out that you have to give primary consideration to what the voter says their residency is and what their intent is. And her intent is undisputed. And I don't think the 4-year language, because of the continuous language, is critical. And the 4 years, the last 4 years, or perhaps not quite 4 years, is the only time when she has had an employment separate from her residency as an emergency medical physician. Thank you.
I have another question, final question, hopefully. And again, going back to the hospital landscape and environment. And I asked her earlier, or I may have asked you, my question is, she is seeking employment, but she has continuously worked, but she has continuously come back and forth, back to her home, back to her bedroom. She has continuously, off and on, voted here in our county with that address. But again, she is seeking employment, but the average person doesn't just want to accept any and every type of job. They want to find a job that meets their passion, that meets their needs, meets their lifestyle, and meets their cause. So therefore, it would seem to me that it would be unjust to expect her to accept any little job that is offered to her. Am I correct? And I kind of got that opinion from her.
Well, I think she's testified to that, and I don't disagree with anything that you've just said.
So therefore, once she is offered a job that meets her experience, her level of expertise, and her passion, which sounds to me like she's trying to find a job here in back
And she's
home,
testified to that.
then she should be allowed to do that.
I agree.
Okay, thank you.
Thank you.
Madam Chairman, I would object to your testimony, which is not in the evidence, both of what you just said there and what you said previously about an internship. For the record, I object to that. We tend to be look at it as evidence and review the story. Make the record of that.
Thank you for your comments. Any other questions of the board?
I just point out, in the Hollowdale case, the Supreme Court said because I didn't object on something, Hollowdale decision, I'm going to make.
It's clear.
Putting evidence in that is not evidence.
Your point is well taken.
There's no evidence or testimony about her bedroom, sleeping in her bedroom.
There,
Where that came from.
sir, your evidence is well taken. Thank you. And to my perspective, it doesn't matter where her bedroom is in the house. She said it's home and it's her bedroom. So I hope that the intent is not of this board to consider trying to go into where her bedroom is. Thank you. Okay. Mr.
What I was going to suggest is my preference here would be to go into executive session,
I
something the
agree.
law allows us to do. This is a quasi-judicial proceeding, give us an opportunity to sort of deliberate and determine. And frankly, I could use a minute just to review the Berner decision a little more carefully. I'll confess I did not look at that before we had the hearing, so I just would like a few minutes in executive session. So I will make a motion that we enter executive session now for purposes of deliberation as a quasi-judicial body.
Second.
We are now going into all those in
Vote.
favor.
We're gonna vote.
Roll call. Aye. Roll call. Please. Aye.
Aye.
Yes.
Yes.
We're now in executive session.
We're missing Deb, I think.
Wait a minute.
I'll wait till Deb comes back to move that we come out of executive session. Ready for us, Deb? Go ahead, no rush. Okay. I'll move that we come out of executive session.
Second.
Aye.
Aye.
Yes. Madam Chair,
Yes.
I move to deny the voter challenge that's before us.
Any second? I'll second it. I'll second the motion. Call for the vote. I would call for the vote.
No, just a vote.
All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you.
Thank you.
Okay. Next. I just want to thank everyone. Thank you. I would just like to thank everyone. It's been an educational opportunity as well, but I also just want to say, this is something that we work through and we deal with, and as the board and as the Hamilton County Board of Election, we are always open, fair, and transparent, and we do everything that we can to make and help our voters feel like they are safe when they come here, that we are confident in what our duties and roles and responsibilities are, and that we do follow the law, and we want our voters to have confidence in us inside the polls and outside the polls. So thank you very much, everyone. Thank you. Next on the agenda is review registration submitted by Black Fork Strategy. Ms. Poland.
Yes, Madam Chair. The organization Black Fork Strategies has been conducting a voter registration drive in Hamilton County, and it's my understanding throughout the state of Ohio. There are a number of registrations that were submitted by this organization that appear to be suspicious, and staff's review of those. And so we have a summary sheet in your packet. I will address the first two voters together, a Cassandra Thompson Scott and a Terry Scott. Both of these voters were registered voters in Hamilton County. We received two new registration forms submitted by Black Fork Strategies in the name of both of these voters, which would change their voting address. That change was completed by our staff, and under Ohio law, an acknowledgement notice was mailed to the voter at the new address that was listed. Both of these voters appeared at our board office during normal business hours after receiving those acknowledgement cards. The new address that was submitted on these registration cards is actually the place of business for Miss Cassandra. And so she received both of the acknowledgement cards at her place of business and came in questioning. She had not moved, and she did not complete a registration form. Staff actually pulled both of these registration forms and showed them to the voters when they were here in person, and they both indicated that they did not complete those forms. And they wrote notations to that effect. And you have copies of those in your packet. We did contact Black Fork Strategies, and they provided us with the contact information of the canvasser for both of these registration forms, and that's documented on your summary sheet. We also received a registration form in the name of Henry Kissinger that was submitted. We did do a match the voter registration database is compared to the BMV database, and it was a mismatch on every item listed, any identifying information listed on this registration form. So we again asked Black Fork Strategies for the canvasser who submitted this registration form, and that is on your summary sheet. Lastly, we've received a number of registrations, and there's a table copies for each of you. The stack of registration form appears, all of these registration forms appear to all have the same handwriting. And they were all submitted by the same canvasser, who is, again, contact information listed on your summary. We've also listed the Southwest Regional Field Director's name and contact information on this summary sheet. We have been working with this individual. Actually, when we first noticed these suspicious registrations, we asked her to come to the office. The Deputy Director and Administrator Chuck Eckert and I met with her and to show her what we were seeing and what was being submitted by her organization. And she said she would take this up with her employees. But we're now bringing this to the board to see what next steps the board would like to take, and it would appear that these need further investigation.
Madam Chair.
Yes, Mr. Mallory.
I've heard of other counties in the state having the same problem with suspicious registrations, and I think we should refer it to the Secretary of State's Public Integrity Office for further investigation.
So I have a couple more questions. I'm sorry. Were you finished, Mr. Mallory?
Yeah.
First thing I want to point out is, we use words like anomalies and suspicion and everything else because we try to be, PC, I guess. But this is fraud. This is outright fraudulent behavior. Who's responsible? How they're responsible? That'll be up to somebody other than me. But it's plain and obvious to me when you get this many registration cards with the very same handwriting that someone is trying to defraud the elections process in Hamilton County. So to the extent that there's any press watching, voter fraud is real. It does happen. It happens oftentimes in the form of phony registrations, all in the same handwriting. So that happens. I'm pleased this board is acting. On the first two that we mentioned, on Cassandra Scott and Terry Scott, those two, both, in case people weren't sort of following, those people were re-registered at their place of employment. Did I get that right as to both?
They were both re-registered.
But to change their address.
Changed
right?
their address, right.
They both alerted us to the problem when they got a notification thinking that we had changed their voting residence, right?
That's correct.
When in fact a phony canvasser tried to change their address. These things cause grave concern, as they should, for a public that wants to believe there's integrity in the process. I have grave concerns about them. I guess my question, first of all, is, Sherry, what can you tell us about the Secretary of State's voter integrity process? Because we have other methods that we could use, including subpoenaing those folks. We have the power of subpoena in this organization. We've used it before. But I also know the Secretary of State has an entire team dedicated to this. Can you educate the board a little bit more about what that team does? Because I'm not sure that's the right, it might be, but I just want to know more about it.
Yes, it is a relatively new department that the Secretary of State created, and it was created to handle, it's my understanding, these exact type situations. They have full-time investigators that are dedicated to investigating any types of suspicious, irregularities or potential fraud in the election process. And we are encouraged to, when we come across those situations, to refer to his office. I think it's another tool, for counties that may not have the resources to properly investigate these types of situations.
Okay. So if we were to do that, that does not keep us from acting into the future if we're not satisfied with the Secretary's progress. Is that right?
And that's my understanding.
So my position on this would be that I'll agree with Mr. Mallory to send it to Frank LaRosa's office, with the idea, however, that, again, hopefully with the agreement of the board, that we put this back on the board's agenda and actually track it. I know that we just recently found out that one of the cases we referred, that the prosecutor's office got felony indicted and prosecuted, and we hadn't really I know we just kind of all picked up on it late, but I was pleased to hear that somebody who had voted in Florida and in Ohio had actually been prosecuted. The media is not going to tell you that, but we found it out here, and I was pleased to hear that somebody had followed up. I would only ask that we put this back on our agenda in the next meeting and get a progress report. And if we get a progress report, then if everybody agrees we can get a progress report as an agenda item on our next agenda, I'm inclined to agree to send it to the Secretary for further investigation, with the idea that we reserve the right to subpoena folks if we want to. We also always reserve the right to send it to the prosecutor's office. And also, the prosecutor's office doesn't need us to act if they see evidence of a crime, which I would argue is potentially evidence of a crime here. They could themselves act in this matter. So I'm inclined to agree, as long as we can all agree to put it back on the agenda to keep an eye on it.
I agree that we should forward this information to the Secretary of State and to their special committee or commission, however it's titled, to explore the options and the validity of the data that we're submitting to them. I believe that we should trust, because that's one of the things the Secretary of State has frequently stated, that this is important for them to deal with this in their way, and we have the option for that to happen. And I support that decision, and I would support sending the data to the Secretary of State's special committee that is skilled in looking at these types of situations.
Yeah. One additional thing from my perspective, the reason I support it at this juncture is we are 90 days from early voting in a presidential cycle. This allows our staff to continue the important work of getting ready to run this election while there's a dedicated team already in Columbus that would look at it. But nevertheless, we as an independent board here, somewhat independent from that whole process, reserve a right to review it again. That's why I would like it back on the agenda. But again, for me, we've been down this road before. We've issued subpoenas before. But given that the Secretary's office does have this relatively new apparatus for us, I think we should give that a test drive so that our board here doesn't, our board here can continue the important work of getting ready for the election. So was that a motion that you made? Or?
Do we need a motion, or can we do direct staff? Okay. I move to refer the Black Fork Strategy suspicious registrations to the Secretary of State's Public Integrity Office.
I second it. All those in favor?
Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you very much.
Madam Chair?
Yes.
I just wanted to state for the benefit of the board and the public viewing that in light of, these suspicious registrations, the director and I have added additional layers of review to the registrations we receive from this organization. And when we see a suspicious registration where like the ID doesn't match, which could result in a situation where these voters could have been disenfranchised had they not received that acknowledgement card. So we're actually sending a letter to voters when we receive a suspicious registration, confirming that the voter intended to update their registration. So we have added extra steps in our process to make sure that these things won't slip through the cracks and disenfranchise voters in the future. I just want the board to be aware of that and the public.
I think that is very good, very important that you clarified that, because I was aware that we were looking at and working on something like that, and it again gives all of our voters in Hamilton County a clear understanding that this board is up to date on and providing safe voting here, not only in the polls, not only here inside the polls, but also outside. And I thank the team of the Board of Elections who is working to make sure that we continue to follow that issue as well. Thank you, Mr. Lenzer. All right. Next is a discussion of the Early Voting Center campaign policy. Ms. Paulding.
Yes. At the May 7th meeting of the board, members of the public requested the board designate separate campaign areas divided by party affiliation on the board's campus during the early voting period. The board voted to seek a legal opinion on that question from the Hampton County Prosecuting Attorney's Office. We have received that opinion. That opinion was circulated to the board, and a copy is in your packet.
So, as a first order of business here, is again a lot of legal wrangling today on our board. So the opinion delivered to us is attorney-client privileged work
Privileges.
product, which would
True.
make it a confidential opinion for only the board to review. Those, that exists in our legal system, for fear that, one side would gain an advantage in litigation. That is, if somebody decided to sue the board, we would be entitled to talk to our attorney privately. That's a very important right in our system of justice. Nevertheless, this is one of those issues of public importance. I know there are partisans in this room on both sides, is my guess, on this question of how to campaign more civilly and appropriately in the designated space. I have for years sort of wondered what the status of the law really is, and more importantly, what our lawyers, our prosecuting attorney, civil team there thought the law would be. So I would like to share this opinion. I'm not entirely sure the view of the board, but we can, as a body, Mr. Stevenson, waive privilege.
Yes.
And I will move that we waive the attorney-client privilege and make this legal opinion available to anyone who wishes to review it, so everybody knows in a transparent fashion what the legal advice that we're receiving is on this important question. So I'll make a motion that we waive privilege as it relates to the June 25th, 2024 Early Vote Center campaign policy legal opinion.
Second.
Any more discussion? All those in favor?
Aye.
Anyone opposed or abstaining? That motion carries.
And we can make copies available to interested parties. I know, like, Ina was interested in it. There's Ina. Sorry, Ina, missed you. So we'll get you a copy of what the lawyers told us.
Yes.
Okay?
Discussion? Anything?
The opinion, I mean, if you're out there wondering and you're here, it basically tells us we cannot regulate content-based speech. Is that a fair summary of it? So if we say Republicans get this space, Democrats get this space, we are regulating your First Amendment right as to what your positions are and where you have to be to have a certain space. And frankly, that comports pretty much with what the law has been for a long time. So if we say today Democrats get here, Republicans get there, it's us telling the public you must be a Democrat to exercise your First Amendment right in this spot, and you must be a Republican to exercise your First Amendment right in that spot. That runs contrary to the First Amendment according to your opinion, right? So I've summarized, what's essentially a fairly lengthy opinion. I'm sure Mr. Hartman's dying to get his fingers on this thing, and you will, Mr. Hartman, because we waived privilege. But anyway.
And I'd also like to ask if there's anyone in the audience that would like to have questions about the policy. If so, please, we'd like to hear your point of view first. I kind of would like to go with our audience first, because I know, but come on up, Mr. Hartman. I want to give everybody a chance to talk. Okay, so we're gonna try and limit.
No, it's just a brief question, and just the thumbnail summary that Mr. Triantafilou provided, I think sounds legally correct. That you cannot discriminate based upon the content. I got the one question outstanding that I think did come up when this was previously raised with the board, is the authority or the ability of the board to limit people solely and exclusively to the bullpen versus just ensuring that they are 100 feet away from the polling place. Does it address that issue?
It does address that.
Yes, it does,
So
very
you can-
Can
clearly.
you summarize that for us, whether or not the board can limit people solely to the bullpen?
Essentially, it says yes, and it sort of describes it as a free speech zone and aligns it with some of the jurisprudence that says that certain zones are appropriate for free speech
Okay,
zones.
I would just call it-
It balances that against the interest of the public.
Yeah, I know there is a decision from Judge Barrett in Durr, actually Liberty Township Tea Party versus the Butler County Board of
I think
Elections,
that's cited in here, actually.
which I think would run contrary to that, but
Yeah.
I'll look at that, so.
Yeah, look, I mean, and if again, for people that are here, again, partisans on both sides, I know passions run high, this is a delicate issue because it is a First Amendment question, and free speech, I think we can all, if we lay down arms for even a second, agree that a free speech right is to be protected, and we debate this point quite a bit. So for us, and for me, I'm the one who actually asked for us to finally get a legal opinion to tell us the reason lawyers and judges exist is, we may or may not be right. That's why we get 5-4 decisions out of the nation's highest court. And a lot of times they get it right, especially lately, 6-3. But that being said, Mr. Hartman, you caught that reference. But anyway, that being the case, I would tell you that, I fear that we will one day have to litigate this question. That is, fear is not the right word, but might be you, Mr. Hartman, but somebody's going to come along and sue the Board of Elections on this topic, and a judge may tell us if what we're doing is right. But in the meantime, we as a board have an obligation to operate under the advice of our counsel, not our own personal views, not our own, impassioned sense of what is right is wrong, but to actually do our fiduciary obligation of the board, and that is, try to protect the taxpayers from unnecessary litigation and things like that. So that's where the opinion is. We'll share it with the group. I don't anticipate a change in the policy of the board based on that opinion. So
That being whatever the memo is, actually.
memo, yeah, I
Is the
think
board
that
going
at
to
this
formally
point-
adopt that as its policy, or
I
is it
think we
just?
have. I think we've done that
we have.
already. So.
Okay. Okay. Is there any addressing it, if somebody does not maintain or stay within the bullpen, what the ramifications are so long as they stay outside? Does it address that?
I don't think it does. I don't believe it touches on that topic. And we have taken other action, right? We had a fellow with a bullhorn that could be heard inside the polling location. That individual was prosecuted, I believe, successfully. Because if you're bullhorning, that's electioneering. It can be heard in the polling location. We've dealt with those issues. Some of the other issues, though, again, I just don't know that it's within the board's power, and especially according to this opinion, to do the things that are suggested or recommended by people that are out there. And anyway.
Okay.
I think, let me just say, I think I'm positive there are people in this room as we speak who are going to be present for early voting and outside voting as well. And I'm sure they may have some questions. So I'd like to ask anyone that has any questions to please step to the podium, please. And I see one hand going up. Yes, ma'am, if you'll step to the podium.
Yeah, I'm Ina Lofspring. So my question is, I understand it's free speech, and what I was referring to is the fact that you could have 10 bullpens out there, but the board is set up as a Democrat and Republican center. You don't have independents and various ones working within here. So what happened on that Sunday was the fact that all 3 bullpens, my free speech, was eradicated, because we could not get any frontage, because they had gotten there so early, and we're volunteers. We have nobody that's paid that comes out there, and no one could speak. You couldn't get to the voters. So where's my free speech? I'm just curious, because you were saying that it sounded to me, and I haven't read it, so I'm doing this by just the little bit that I heard. It sounded to me as though that if you designated a Democrat and Republican space, I mean, you could have an RFK space. You could have, anybody can go in any of the spaces. I was just saying it seems like there should be 2. What happens with my free speech? Is that addressed?
That's addressed in this as well. And I would just like to make a comment. One of the things that is so important, and we say this on early voting, and even the comment that you just brought up, we must be civil.
I agree.
We must not use language in any way that is
I agree.
threatening or intimidating our voters.
Absolutely.
When a person calls that free speech, that they feel that they have a right to intimidate the voters or yell and scream at them, that's a problem.
That's a problem. I agree.
I'm
I
glad
agree.
that you agree.
I
Thank you.
absolutely agree. When you don't have any frontage, and everybody takes the front of all 3 bullpens, and I'm told it's first come, first serve, and I don't have, getting there at 6:30 in the morning, I don't have anybody to get there at 6:30 in the morning.
And I think I know this is why this document is very critical and is very important.
Yeah.
Thank you very much.
Thank you.
Yes. We have another speaker.
I don't understand why,
Could you give us your name?
I'm
please?
Greg Fritz.
Yes.
I don't understand why the issue is not first come, first served, because if if everyone's offer of free speech and I'm there first, why can't I have as much free speech as this lady over here? None of our volunteers that I know of are paid. I don't know where that assertion comes from. So if I'm there at 6:30 in the morning and I want to sit there until 8 o'clock in the morning and wait and have my spot in line, I don't know why my free speech should be infringed because they have to have, or she has to have a spot in the front of the line.
It should not be and it shouldn't be. And that's what this is clarifying as well. Yes, I see a hand up. Yes. Sorry.
Christine Zebon.
Yes.
I usually do 6:30. I usually get there early, and I have to say, and I differ that anybody that I see in the morning's paid. I'm a volunteer. I'm not paid. I get nothing. The majority of the people I know are friends, and they're not paid. And the other thing is, I have never seen, now again, I'm there in the morning, can't speak about the other part of the day. We get to one spot. I have never seen us spread out. And if we did, we should be in a bullpen. We usually contain ourselves in that bullpen. We have obeyed the new rules of no tents, no signs, no nothing. And we are 100 feet away. I am very adamant that I personally don't want to see anything moved. If anything does change, I've called both Alex and Sherry and have notified them if there's something going on to keep peace. So I feel the rules are being followed, But I don't know about this one Sunday. I wasn't there. I can't vouch for a Sunday. But I think as much as possible, we're handing out the slate cards and we're keeping to one. Like I said, I'm not there after 11 o'clock, so I can't vouch for that. But to say that we're paid, I think examples should be made of who these people are. To assume that is not right. And that's it.
Thank you. Thank you very much. Anyone else? Okay, thank you very much. We have, yes. Can you step to the, you do. Yes, you do. Yes, you do.
State your name for us, ma'am, as you come on up.
Kathy Cool. I just have a question about the location of your policy. Where does one find it? On your website?
Well, you can go if we can put it on the website, but we have to be.
You can simply make a request. You're looking for the board's policy.
Like if anybody in this office,
You can make a public records request. You can just see our staff on your way out and ask for a copy of the policy.
Okay.
If you're wanting the legal opinion, we've pre-made copies of those.
Okay, so my first question is, how do you find the policy? And you say someone has to make a request to get it. Is that correct?
Correct.
We have policy. We have copies. We have copies for you.
Okay. Now, the second question is, will the legal opinion in any way affect the policy?
The legal opinion is the policy.
No, the answer to
Okay,
with all respect to our
because you
chair,
just requested this, and I didn't know if
right,
in any way.
Our policy came under some scrutiny,
Right.
so we scrutinized it and asked for an official legal opinion because
Okay.
of the delicate nature of the question on the First Amendment, and we have received an opinion, and I think at this juncture, the opinion of the lawyers is that our policy is
Okay.
legally
So
sufficient. So-
Nothing in that opinion would have any effect on making a change in your
Not
policy?
at this juncture.
That
Not at
was
this
my
juncture.
second question. All right,
Exactly.
thank you. So then when I
Thank
leave,
you.
I can, who do I ask, Sherry?
Any one of our staff that are out front
Okay.
can assist you.
Great, thank you.
Thank you very much. Anyone else? Okay, seeing none, I want to thank everybody. If you have no questions, we're going to move on with the agenda. Next on the agenda is the is the approval of the 2024 equipment allegation.
I'll move approval of the recommended equipment allocation for the 2024 election.
Second.
All those in favor?
Aye.
Aye.
Anyone opposed or abstaining? That motion carries. Next is the approval of the November 2024 ballot and provisional envelope quantities.
I'll move approval of the 2024 ballot and provisional envelope quantities as recommended by staff.
Second.
Any discussion? All those in favor?
Aye.
Anyone opposed or abstaining? That motion carries. Next is approval of the 2025 proposed budget.
I'll move approval of the 2025 proposed budget.
Second.
Any more discussion? All those in favor?
Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Any other business, Ms. Poland?
There's a copy of the organizational chart. It does not need approval. We just know it's been a while since we've given the board a copy of our organizational chart. Moving into the presidential, we wanted you to have a copy.
Thank you. Thank you for the update. Okay. Mr. Linzer?
Yeah, I know this meeting is going long. I will be quick, but our Secretary of State Liaison, Kenny Henning, is not here today. He's up in Columbus. But if he were here, I'm sure he would take delight in updating this board that at the Secretary of State's conference last week,
Oh, yes.
our own Sherry Poland was honored with the Election Official of the Year award by the Ohio Secretary of State.
Good job.
I've had the privilege to, to travel across the country as I'm working on national certification for election officials. And I hope the people of Hamilton County know that election officials across this country look to Hamilton County as an example of an office that is run right. And that starts from the top. It starts with great leadership. And I just wanted to congratulate the director on winning the award. It was well deserved.
Let's give her another
Congratulations,
hand.
Sherry.
And I was at the conference as well, and it's encouraging, and it's also really neat that our Hamilton County Board of Election staff are praised for being open-minded, being able to work together collectively, no matter what your party affiliation is, because that's what it's all about. And they exemplify that, and we should exemplify it ourselves as we work together in the community. It's all about being civil, no matter who you are or what you bring to the table. And that civility, to me, is critical. And I see that with all of our staff, we as the board. We're Ds and Rs up here, but we get along very well. We can agree that we can disagree at times, but when it's all said and done, we respect each other and we're civil with each other. So again, thank you all. So give the staff a big hand as well. All right. Need a motion to adjourn?
Move to adjourn.
All those in favor?
Aye.
Aye. This meeting is adjourned, and nobody can stop it but the devil, and he's not here.